And so what does it mean to be held in trust? It means simply that someone else, although it can be you, is in charge of check writing of the money that's being left for you. And there are different kinds of terms around what the language about who can be in charge. So let's say the typical plan is, I'm giving everything to my spouse, it's going to be in trust for his lifetime, and then when he passes it goes to our kids. I want it to be in trust because I'm worried about creditors, I'm worried about predators, I'm worried about all of the things that we've talked about. And he says, yeah, but you know, I want to be able to have free reign use of the money. And so we can say that for things where he has the right to pay for support, maintenance, the customary things, he can be the only signer. But if he wants to use the money to buy a yacht to go to Bimini, he has to have her sister, which is always my favorite, when people want to have his sister-in-law be the co-trustee of the money for him, so that when he does remarry, she's given out nothing to that other woman. So it's kind of an interesting play on what people do about these things. But my point is simply have conversations with clients about how the trust should be structured. What kind of powers do you want? One of the things that you can do is you can give your beneficiary, who's also perhaps a trustee, the power to appoint what remains after they're gone. New Jersey allows all of these procedures just like New York does, but whereas New York allows for what's called a decanting of the trust, if you've made some decisions in a trust that in hindsight would be better served in a slightly different way, New York has a provision by statute that allows the trustee to pour or decant the trust into a new trust that has slightly different terms. New Jersey doesn't have a statute like that. We have a case, you have to go to court. It's not a perfect solution. It has issues. It allows for more unpredictability than you would perhaps in New York.